Okay, so here we are, part two. Just for those who perhaps are joining us for part two who weren't here last week. My name is Joanmarie Dowling. I'm a labor and employment attorney, and our firm works with a fair number of human services organizations, including organizations who are providing rehabilitation services. And so we're here to talk a little bit about some of the employment law issues that are associated with some of the work that you're all doing. So the first week, last week, we talked about mostly Fair Labor Standards Act in connection with, in connection with unpaid work experiences and what can be an unpaid work experience and what can't. We're going to talk a little bit about New York State and then some other employment law issues this week. And I think it's important just to remember that when we're looking at labor and employment issues, we have both the federal law and the state law, and they don't always coincide so nicely together.
God forbid it would be easy.
We have to worry about both. And so when we're looking particularly at unpaid work experiences, we need to make sure that we have justifications under both federal and state. And sometimes we'll have multiple justifications for treating something as an unpaid work experience. But at any rate, so without further ado, just as a reminder, we're going to talk generally today. There are a lot of specific questions in terms of applications to real life situations that you might have. We're probably going to talk more generally. I'm happy to talk one-on-one with folks after the presentation about more specific issues related to their program. My contact information is on the last slide of this presentation. So, just as a review, who is an employee? An employee is anyone who the employer suffers or permits to work. And as we said, that's a really difficult definition to wrap our heads around, but generally speaking, under both federal and state law, a worker who's performing any kind of services for an organization is presumed to be an employee unless we have an exception that applies. So we're going to talk about those. Remember, when we're talking about unpaid work experiences like federal, there are certain ground rules. Typically, the experience has to be voluntary. Everybody has to understand that the individual isn't going to be compensated. Unpaid workers may not displace paid staff. The experience has to benefit the individual more than the organization that's hosting the experience. There can be some benefit to the host organization, but generally speaking, it has to be more in favor or more beneficial to the individual. And the experience has to be time limited in some way. For those who didn't join us last week, we talk about this in a little bit more detail in the first session.
Can I ask you your opinion on something? I'm reacting to the first quote that says, experience must be voluntary. In the service realm of things, quite often, not quite often, it's kind of said in things that are funded by Medicaid, in particular pathways to employment on the DD side, even some of the waiver services that are being talked about under the HARP for people with mental health recovery issues. Agencies are developing unpaid work experiences, but the people actually have to do that in order to get a support. So the voluntary piece of this, it's sort of mandated if you're going to receive that service. So the voluntary is actually having a conversation with the individual and saying, here's what your choices are, here's what your rights are. Is that what is meant behind that voluntary, actually having the conversation versus you have this or this to do? There may be only two choices. If you want the service, you have to do this or this. If they get placed, then that's not voluntary, right?
Yeah, it's a little bit challenging because most of the time, this is really in the context of individuals who are employees or individuals who are not participating in some kind of program per se, but the voluntariness typically relates to an individual feeling forced to do it in order to either maintain employment or to obtain employment with that particular organization. So I would say it's probably worth some further discussion about those kinds of programs and voluntary voluntariness.
Yes, yeah. Well, I just wanted for everybody that's listening, I know I probably, but there's room for audit interpretation there at times, and so I just want you guys to be careful. And a lot of this, the language, I was with the past 2 days with Jill Dorsey. We were working with the rehab managers of some of your agencies, and we were talking about language and interpretation, and voluntary becomes, it's a crossover. This is a labor discussion, so the word volunteer and voluntary mean one thing, but in the rehab world, voluntary means choice, and yet in business it may not include a choice, right? It's just kind of, yeah. So yeah. I just keeping you on top of, you're listening to a presentation about how labor laws have to be included in this world that you are building as you're supporting people with Medicaid-funded services, and sometimes not only on the state and federal side from labor, but what happens in a Medicaid definition or a VR definition may not necessarily be the same connotation as what labor is. So keep track of that. If there's other questions or thoughts, feel free to send them to me, or we'll, like you said, your contact information is at the bottom. So just keep that in perspective as you listen to the rest that Joanmarie is talking about.
Yeah, I think it's an excellent point that these rules, these guidelines and case law typically isn't anticipating the application in the work that you're doing. Certainly they would apply those rules when the case comes up, but the guidance may not be, it may be that we're living in the gray, which is where I thrive, because that's why you hire me, but it may be that we're just trying to position ourselves as best we can. So under New York, there are a few different ways that you can have an unpaid work experience. The New York State impairment exception, interns, volunteers, learners and apprenticeships, and students. And we're going to walk through each one of them. The first is probably in some respects the broadest, and that's the New York State impairment exception. Under the minimum wage order, which is essentially the regulations that the New York State Department of Labor issues to enforce minimum wage, there isn't going to be an employment relationship under the minimum wage order when an individual provides services to a not-for-profit and the individual's earning capacity is impaired by age or by a physical or mental impairment. You will find from time to time that I use language that some folks may like or not like. We are tracking the legal statements, what the New York State or other agencies or courts might use. So I just want to, I think largely we should be okay, but just in case anybody is wondering where we get this terminology, it may not be the same as what you use. So where does this apply? Well, it really applies where an individual's age or their physical or mental impairment impairs their earning capacity for the work the individual is assigned to in this particular circumstance. So you may have somebody who can perform very well in a manufacturing setting, in a work center or other place, but perhaps the work that they're doing is receptionist work. So they may be impaired in that way, but have an interest in doing it. And they may not be impaired in other places. If they are not impaired for the work, then this exception would not apply. So we would need to have documentation of the age or the physical or mental impairment. For the impairment, it would have to come from a healthcare provider that talks about the nature and extent of their condition. And we'd need to have a description of how and to what extent age or disability affects the individual's earning capacity for that work. And remember that this only applies in a not-for-profit setting. I would say also I'd be very cautious of trying to apply this in a commercial setting. So if you're providing, if your not-for-profit has services that really are commercial activities, like manufacturing, like janitorial services, or those sorts of things, I would be very wary about relying on this, and I certainly would do a more intensive legal analysis of that. Okay, so the next category we have is students, and a lot of these you're going to remember from last week are the same categories that we had under federal law, but the standards are a little bit different. So in New York State, the students have to be attending some sort of institution of learning. They have to be working towards a degree, a certificate, a diploma, or if there are residency requirements for a particular degree, that they're doing that. They can be students who are between sessions. So for example, in the summer, they can be a recent graduate, which would typically apply when they're going to graduate school. But there can be these gaps. Typically, we're looking for not more than 6 months between when the two times that they are, excuse me, active students. So the not-for-profit standard is pretty basic and provides some flexibility. So for not-for-profits, the individual has to be providing some sort of service that's operated for charitable, educational, or religious purposes. So remember that that's not all not-for-profits. There are nonprofits that are out there who aren't formed for one of these purposes. But if the individual is working for an organization that has one of those purposes, and the individual is a qualified student, so they meet the test that we just talked about just a few minutes ago, that they attend the institution of learning, they're working towards those that kind of program. Then the individual can be unpaid, even if it's not directly connected or required by the curriculum or what they're studying. So we have some flexibility there. An individual is not going to be deemed to be an employee if they are supervised, they're working on vocational experiences, if they have some sort of, this is for-profit. So for the for-profit rule, it's a little bit stricter. It has to be connected up with curriculum requirements. It has to be required for the curriculum. So we're looking at a much more directed connection between the schooling and what they're doing. So more limited than the exception for nonprofits, for charitable, religious, or educational corporations. And I would say if you have another type of non-for-profit, even though Department of Labor isn't specific to that, I would say they would probably be falling within that for-profit rule. So there are requirements that you have to keep. Just because they're not considered employees, you do still have to provide documentation to be able to substantiate the classification. And there are employment records that the records you have to keep are similar to employment records. Obviously, as we talked about last time, we're not going to call them employment records. We're going to want to make sure that the documentation doesn't represent the individual as an employee. But we would want to have information about when they're working, and have additional information to substantiate the kind of work that they're doing as well. I think is a really good idea. So remember that we have different rules here depending on whether they're for-profit or not-for-profit. And let's compare it to the federal for a minute. If you remember from last week, under the federal, you have to show the sequence of activities that builds on the other. We're looking at developing higher level, higher order thinking and problem solving. So the standards in terms of the content of the student experience is much more robust under federal law. So it is likely that you could have a fair number of student experiences under state law that wouldn't qualify under federal. You'd have to find some other federal exception that would apply.
Do you know, Joanmarie, in regards to any of the things that under WIOA, the Workforce Innovations Opportunity Act, and they talk about students there and requirements, are you familiar enough with that, or maybe we can talk some more, because that's a federal law. That's why I'm reacting. It's a federal law, and whether or not the federal law then uses the federal definition of student, or because we're in the state, can we interpret it for using it under the state process? How would that, do you have An opinion, Mr. Attorney?
Well, I'd say it's certainly worth having some further discussion.
Okay.
But when you're looking at the WIOA process for students, I would say that might be one of the exceptions that you could use under federal law that would be different from the traditional standard.
Okay.
So I would see, even though it's confusing because they use similar terminology, unfortunately it's one of those places that I think we can see that every statute or every exception is different, which is why people hire me. So I guess I should be too disappointed, but it can't make things very complicated.
Okay. Thanks.
So internships, remember we also had a federal internship exception. Our ground rules still apply, so we want to make sure it's voluntary, that they're not promised compensation or employment opportunities as a part of the work that they're doing for that particular work experience. We can't be displacing employees, so we can't have groups of employees who are essentially completing the job of a department or a particular segment of the business. Can't be filling a vacancy that would typically be an employment vacancy. In New York, there's an additional requirement that there be notice that to the individual, and I would say also to the individual's representatives, that the individual won't be eligible for compensation or employee benefits. I would recommend that this be in writing so that you can establish that you did comply with this. And recognize when we're talking about internships here, we're still talking about unpaid work experiences. So there are individuals who are paid interns. If you're meeting minimum wage and overtime requirements, then you don't have to obviously provide this notice. It's really just to justify treating those unpaid workers. Okay, so now we get to volunteers.
The hot topic in rehab, right?
Yeah, we often hear people use the word volunteers when we're really just talking generally about any kind of unpaid work experience. Like federal, you can't have an individual who is performing volunteering for a for-profit entity. So nobody can volunteer for my law firm, for example. Further, they can't volunteer to perform commercial activities. So to the extent that you're performing services or preparing goods or services, those sorts of things that you're selling to other organizations, that would be a place where individuals can't volunteer. We have to use one of the other exceptions if it's going to be an unpaid work experience.
Here's a trick, Joanne.
Sure.
What if, or as if, and that it happens, you have the for-profits that run marathons that raise money for others. People can be volunteers for the event since the end product is not commercial. Or is it, again,
I would consider that in those sorts of situations, and it may be that they have a separate foundation, but they're really not volunteering to perform services for the for-profit. What they're really doing is volunteering to support the particular not-for-profit or groups of not-for-profits.
Okay, it just happens that they're the for-profits, the sponsor of the event. They get Freihoffers, Women and People. I know quite agencies here in the Capital District sometimes get asked to put bags that get given out to every runner, that kind of thing. So
right.
those are perfectly okay because they're volunteering for the charity event, not for the for-profit.
Right, as opposed to somebody volunteering to go through my filing, which, I mean, if anybody wants to do, I'm sure you can find some sort of way of making that unpaid. But yes, no, exactly, it's a really good point. And really what we're looking for is some connection to the benefit, is direct benefit to not-for-profit organizations.
Got it. Okay.
So our ground rules still apply here. And just to compare this with the federal for a minute, remember last time when we were talking about the federal volunteers, they had to be volunteering for some sort of altruistic purpose. They have to be doing it for the betterment of society or to support the particular work mission of that organization. And so when we were talking about federal volunteer, we said, it's probably not going to apply to any of the work experiences that you all are working with individuals to provide, because they're not really doing it for a charitable purpose, for example. They're doing it because they want to develop skills or explore interests that they might have in order for them to be able to work. And so that would satisfy the requirements for federal. Under state, however, they may be able to use the volunteer exception for unpaid work experiences. There is a specific rule with employee volunteers, which I think we may have talked about last time, and that is you can have individuals who are volunteering to perform the same services that they provide as an employee. So we do see, for example, when nonprofits do their own fundraising, sometimes people who might be doing very different kind of work will volunteer for a fun run or those kinds of things. If that's different than the work that they would normally do, it's voluntary and we meet the ground rules, they can volunteer in that capacity. If you have an individual whose job it is to fundraise, for example, they can't be volunteering, or somebody who's providing administrative support generally, and then also for the particular event would have to be paid as an employee. Excuse me. Additionally, under state rules, there's a specific requirement that they can't be required to work certain hours. Now, I know that that's a little bit more challenging for organizations, because when you have individuals who are doing unpaid work experiences, we need to plan for that. And so that can be a little bit challenging, particularly for the hosting organization. It's one thing that I would say isn't necessarily going to mean that we can't use the volunteer rule at all, but I would be very cautious. I'd be looking to see, are there ways that we can provide some flexibility, if they can have a choice as to when they're going to be working, for example, or if we're kind of negotiating on a person-by-person basis what would work for this particular individual. But if you have somebody, particularly somebody who's working a fairly regular schedule, that'd be something that the Department of Labor would look at in assessing whether somebody really wants to volunteer.
That's very interesting, because I'm thinking, scary. I'm thinking of our agencies that support individuals through DAHAB funding. Rehabilitation services are billable to Medicaid, and I would beg to say that they have a regular set schedule. People, for the most part, go to the same jobs at the same time and are expected there. So this is bumping up against that in a very big way, and maybe something that I need to follow up on with people who are doing that, put it that way. I know all the agencies do it different ways, and they certainly give people the opportunity to switch off and try something, but different. But for the most part, everybody goes and does the same job as a volunteer 3 days a week at the same hour, because that's when the van's leaving to take them to that volunteer job. And you're saying that that could be a problem.
Well, so maybe
and I'm sure it could, because we don't know for sure.
Right. It could be that they don't satisfy the volunteer argument or application, but it may be that they fall into a different category. And remember, something can satisfy more than one test.
True.
So we're certainly going to be looking at making all of the arguments that we can. Really, part of the purpose of this is to be proactive, so that if there are things you need to do to provide some flexibility. So maybe individuals, generally are expected to go 3 days a week, but maybe there's some flexibility in terms of which days those are. Maybe they have people going every day. So there may be ways of being able to structure it, at least to try to preserve the argument, if you have a Department of Labor audit or some sort of claim brought against you.
Okay, thank you.
Okay, so now we talk a little bit about learners and apprenticeships. Under New York State law, the learner exception is only available to nonprofits. It is a part of an individual, or it applies to an individual who's part of a training program that the not-for-profit operates, has set up, and the nonprofit has to be set up for charitable, educational, or religious purposes. So what's a training? Well, the training, to be bona fide, has to involve some sort of formal instruction and on-the-job training. That means we don't just throw somebody on the phone, but there's actually process as a part of what they're learning. So it may be classroom time, or there may be some other mechanism by which an individual is getting more than just, here, let me show you how this widget gets put together, but some additional learning around that. They, during the training program, can't really be working independently. They have to have limited responsibility. They have to be have some close oversight as a part of this. This is really them learning this particular job or this particular skill. So they really shouldn't be working too independently. If it's something they can pick up pretty quickly, then maybe they don't qualify as a learner anymore. It has to be at least 2 weeks, not more than 10 weeks. So if you have something that's lasting more than 10 weeks, we're not going to be able to take advantage of the learner exception. Apprenticeships, there's apprenticeships in New York State and in federal. I'll talk a little bit about the federal in just a minute. Apprenticeships in nonprofits are exempt from minimum wage and overtime. For-profit apprenticeships must be paid. And under federal rules for apprenticeships, the expectation is that those are going to be paid. To have an apprenticeship that will qualify as an unpaid work experience, they have to qualify as a bona fide training program. So we're looking at a program that's going to happen over the course of time. It has to be in an approved trade or occupation. It has to be approved for apprenticeship. So you can't just have an apprenticeship on anything. And there's actually a Department of Labor, New York State Department of Labor website page where they actually provide a listing of all of the different things that could be an apprenticeable trade or occupation.
You are exempt from minimum wage. Is the 14C prevailing wage process available under this, or are we still just staying unpaid?
So they wouldn't actually be required to pay minimum wage and overtime. They could pay something under this particular
So if an agency
exception.
had a 14, because it can be a not-for-profit or a for-profit, if they, could we still see the 14C certificate being acceptable under an apprenticeship program, or not a good idea?
Yeah, I think you could potentially have both. Okay. It would have to, actually qualify.
Yeah, the bona fide training, but I'm thinking there's one agency in particular that looked at the ability to. They had a need for forklift operators, and so under a machinist kind of thing, and teaching that they were going to run a 2 or 3 week training under that and see if they could get it approved as an apprentice, because there are lots of places that need forklift. Yeah. And there's specific things you need to know and you have to be able to do with the machine, all that kind of stuff, so there'd be a bona fide training. There is actual training that can do that, so they were thinking about that, but they wanted to incentivize that process by using, during that training period, still being able to give them some kind of wage to encourage.
Yeah, and a 2 to 3 week kind of program is more likely to qualify as a learner program, as opposed to apprenticeship program. Okay. But certainly, unlike some of the other places where we had the ground rules that applied in terms of not being compensated, in learner and apprenticeship, that doesn't apply in the same way. So it may be that somebody qualifies as, as a 14C or other, other kind of process. So what kinds of work might be apprenticeable? And I just gave kind of a list of some of the things. So, we often think of apprenticeship in terms of electrician or plumber or other types of construction or manufacturing, but in fact, actually, there are other types of work that can qualify for apprenticeship. So for a bona fide program, it has to be at least 2 years, and they're looking at 4,000 hours. It has to be general to the industry, so again, some skills that are transferable, not learning how to do work at one particular organization, but skills that they could use if they wanted to go someplace else. There are particular requirements in terms of documentation and schedule so that the apprenticeship program can establish that there is a process for learning and getting experience. Again, it's not just throwing somebody in to learn the work, but there has to be a particular process, and that you would go through as a part of actually getting approved for providing apprenticeship.
Are you familiar? Do BOCES programs? You know, could they actually do apprenticeships? Because I know I wonder if that's because the student's still under the, you know, K-12. That's not really it, but an extension of what they've already done at a BOCES. You know, in any of those categories. Many of the things that you had on that example list are actually full-fledged training programs that happen for the student, along with their academics for the requirement for their diploma, but they don't get into the 4,000 hours of bona fide training. They get enough to get a certificate from the BOCES and graduate with their diploma, but there would be the next phase, perhaps. Is that the idea?
So it could be that I mean, I don't think there's anything that would prohibit BOCES from deciding that they wanted.
Right, because they can do adult education as well.
Right.
Yeah.
They may be using a student exception,
Okay.
Because it would be connected to the schoolwork, working towards a certificate. So there may be other ways that they're justifying it. But
I bring that up only because I've been encouraging agencies that are NYSER members and do all this vocational support to build a relationship with, because of the CDOS, the CDOS credential that's available to all students, the ability to learn more about what BOCES programs are actually doing in their programs, and then figuring out how to extend that and work as partners to support the student towards the world of work beyond what they can do, perhaps.
Or to utilize the same program, I would expect, for individuals who are not students currently, but there may be processes that can be adapted for others.
Our guys have lots of cool things going on in their work centers that perhaps could turn into the ability to offer something else, and then they continue to work. So, okay, cool. Thank you.
So as I said, under federal law, there isn't a minimum wage or overtime exception. What they expect is that you're going to meet minimum wage requirements with increasing wages as skills increase. So the idea is that the individual starting off with sort of basic work skills and moving up and getting more and more sophisticated, so that they are going to be ultimately making much more than they would before the program. So that would be an incremental change. Okay, so that is the end of our kind of wage hour, how people get paid when they have to be paid, and what exceptions that we have, more specifically when they're not getting paid. But I did want to talk about some other issues. And first, we just start off with anti-discrimination requirements. As you may know, anti-discrimination requirements can come in a variety of different ways. You may have heard of public accommodations. Both federal and state law have prohibit discrimination on the basis of a number of different protected traits. And those may include race, religion, color, national origin, sexual orientation, military status, gender, and other, and certainly disability would be some of the different ways that or individuals who would be protected. So what's a public accommodation? Those are facilities generally that are open to the public. We think mostly of bars, restaurants, hotels, movie theaters, and those kinds of organizations. They have to be open and accessible to individuals with disabilities. They can't discriminate on the basis of disability or other kinds of protected traits. There are also anti-discrimination rules associated with programs that are receiving federal funding. So you can't discriminate against individuals in terms of participation based on protected traits, including disability. Additionally, both federal and state law use kind of the power of the purse to put in some additional non-discrimination rules through contracts. So like, you know, GE, IBM, and Dowling Law, the federal and state government has to purchase services and goods as well, you know. And as a part of the contracts, they will put in particular requirements against discriminating against individuals who are employees or applicants on several different protected traits, including disability. And so they use that as part of their negotiating process so that individuals or organizations that are federal or state contractors can't discriminate against individuals who are applicants or employees with respect to the work that the contractor is doing for the federal or state government. So what do we mean in terms of applicants or employees? Who is an applicant or an employee, but also like what happens with all of these other employment protections that many of us have as employees. So New York human rights law is the state law that prohibits discrimination on the basis of a lot of those protected traits that I talked about. We have the ADA, the Americans with Disabilities Act, the Age Discrimination in Employment Act that would prohibit age discrimination, and Title VII, which would protect against a number of traits including sex, national origin, color. So what about those? Do those apply to individuals who are in work experiences? And the beautiful thing for me, of course, is the answer is it depends. If it were a straight rule, we wouldn't need lawyers. So under federal law, it's an individualized assessment. We're looking at the facts and circumstances of each work experience. And so that's one of the things that I just can't reiterate enough, that oftentimes we do things kind of based on programs, and that is not always the best way of doing it, because we may have people in varying circumstances with different kinds of experiences under the same umbrella, the same program. So we do want to think about whether there are subcategories or even individuals who are a little bit different that we have to look at. So under federal law, if the experience is unpaid, we're looking at compensation or other benefits. So for example, do they get travel expenses and other kinds of things paid, and how much does that look like? Do they, are they provided employee benefits, those sorts of things. But generally speaking, if it's unpaid, they're probably not going to qualify as an employee under federal law. If they're paid, we're looking at what is the primary purpose, or what is the primary role of the experience. Is it intended to be a work experience, an employment relationship, or is it something that's really much more of an intern kind of position? And this is an area that's evolving. I would expect that we would see more employment status, even if the individual is okay to be unpaid. Generally speaking, particularly with interns who tend to be either students who are first starting off in a particular, you know, industry, or are new to employment generally, or individuals that the courts consider, or the Department of Labor considers to be vulnerable. They're more likely to want to extend anti-discrimination protections for those individuals, because we don't want them to be abused. But generally speaking, what we're looking at is does this look like employment, or does it look like some other kind of experience? New York's a little bit more straightforward, and I told you that you know, agencies and courts are more likely to want to have protections for individuals they consider to be perhaps more at risk. Under New York State, they spell it out that paid and unpaid interns have the same kinds of anti-discrimination, anti-retaliation protections as employees under state law. So who's an intern? An individual who's performing work for an employer for purposes of training. Typically, there's no promise of employment or no wages, although paid interns are also covered under this particular exception or this particular protection. And the work performed usually is supplementing or providing some kind of training that would help the individual become more employable, provides an experience that benefits the individual and doesn't displace regular employees. In this particular case, to be honest with you, if they're performing services, you know, if they're not an intern, they're likely an employee. In either case, they would likely be protected from discrimination under state law. So, sort of briefly, it prohibits discrimination or harassment based on any trait under federal or state law, a lot of which we just talked about. It also prohibits retaliation against individuals who are opposing unlawful activity under state law, under anti-discrimination state law, or who files a complaint. So it may be that an individual files a complaint with the State Division of Human Rights, which is the agency in New York that enforces anti-discrimination laws, or it may be that they simply are opposing it, even if it's happening to somebody else. So one of the things that the statute does that I think is really significant is it specifically says just because you have an employment relationship for purposes or you're protected for purposes of New York State anti-discrimination laws doesn't mean that you are also an employee for purposes of labor law, so minimum wage, overtime, how wages get paid, unemployment, and those sorts of things. So again, it reinforces that the state understands you can be an employee or you can be protected under one statute and not be an employee or not be protected under another statute. So if somebody is discriminated against, and let's say that they are unpaid, we're not looking at lost wages, but what kinds of things might happen in that circumstance if an individual is in fact discriminated against, and you can look at reinstatement if they've been let go from their work experience and it was intended to continue. You can have emotional distress damages or other kinds of damages, and those could be pretty significant, including like 6 figures, even if the person didn't seek any kind of medical or psychiatric assistance. Attorney's fees if it's a sexual harassment case, and civil penalties. So what do we want to do in those kinds of circumstances? Well, if we're actually developing our own agency policy, we probably want to include interns specifically, as well as employees and even vendors and other kinds of individuals, even if it's not required under the statute. We can have a broader policy than what's legally required. And if there's a complaint, even if we're not sure whether the individual is actually an employee, we probably still want to take action if it's at a work site that's not at the agency, but a community placement. We still really want to take those seriously and work with the work site in addressing any issues. Okay, the part that probably a lot of us have been waiting for, federal payroll, taxes, and withholding. So the question is, or questions are individuals employees for purposes of FICA, so that's Social Security and Medicare, and income tax withholding? Are individuals subject to self-employment taxes, which would happen for independent contractors? So there are a couple of different things that we want to talk about. One is the 1993 letter ruling that talks about employee and independent contractor status for sheltered workshop settings. In particular, there's one. And just as a point, a couple of points. First, a letter ruling is something that is specifically requested by a particular employer. They provide a description of the facts, and then they ask the agency, what do you think how would you interpret the law as you apply these to the facts? So one is that they are restricted in terms of reliance, generally speaking, in a couple of ways. One is nobody who isn't that particular employer seeking that information, or that particular organization seeking the information, can rely on it. So I can't look at this letter ruling and say, well, because of this is how the law should apply to me. It's maybe persuasive, it's worth talking about, but it is not binding on the agency, it's not binding on the courts. Similarly, the agencies are always very quick to say it's based on the information that you provide us. So if the information has changed, or you missed what we now think, or we thought then would be relevant information, then all bets are off, and our opinion means nothing. So in this particular situation, we had a sheltered workshop setting. They were doing a number of different kinds of projects. Individuals were working under the supervision of a team that included rehab, in some cases residential staff, other kind of healthcare providers. And the individuals weren't disciplined for failing to meet goals. They were only discharged if they were uncooperative, they failed to attend, or they were functioning at too low a level, and that's what they used in the letter itself. And so that might be a little bit in the eye of the beholder. Some individuals would, quote unquote, graduate to work in private industry, and then they would get paid by that employer. Under these particular facts, individuals were working under 14C. They were being paid at a piece rate or adjusted hourly rate. They were, in 1993, average annual wage of less than $5,000. And individuals were not living off what they were making. They weren't eligible for benefits except for workers' compensation. So what did the IRS say? Well, the IRS said, look, the relationship is primarily rehabilitative. It doesn't look like employment relationships to us, and so we don't think that FICA is due. We don't think you have to employ or withhold income tax, and they're not independent contractors for purposes of self-employment taxes. So one of the things that I hear about is individuals saying that they treat 14C sheltered workshop employees as independent contractors. That's not the case. They're not. Remember, we talked a little bit last time, independent contractors are generally people who are in business for themselves. Somebody who's working on a workshop floor in production is not in business for themselves, so they're not independent contractors, but this is essentially saying that there's not an employment relationship for a different reason. Now remember, this is from 1993, and as I was driving over here, I realized I actually have an employee who was not born at the time. She was not living at the time that this was issued. So the law continues to evolve, and it's important to understand that what happened, some years ago, may not reflect the law as it is currently.
Plus, if you go back 2 slides for
Sure.
me, where you start right there. That very first bullet, for those of you that are listening and are part of the rehab world here, and contemplating that in light of the guidance that was issued by OPWD, that you are, as an organization, determining to change your business, your sheltered workshop, to a different kind of business, you therefore will not meet that very first bullet. You are no longer a sheltered workshop setting. So, without even meeting, if these were indeed the facts that still play out for your former or existing, but now you're looking to do something different, if you don't meet all of those things that were originally what the IRS ruling for your organization were based on, I would surmise that you no longer have that in effect. That ruling, that letter ruling, is in effect for your organization. So I would be careful to review each one of the facts as Joanmarie has kind of laid out in this case study. Are you still meeting all of those pieces to be able to argue that your IRS ruling letter stands? Even if it's old and whatever, somebody might still be willing to take on that. But if you're not indeed with this new work environment, new potential business plan going to be able to meet all the things that you've originally put in the IRS ruling letter, you're out of luck, is what I would say. And I'm no attorney, but I'm going at it. It's a pretty simple, straightforward. It was based on you convincing them at the time that this is what was going on, and they made a decision based on those facts. If those facts no longer are in place to help you make that argument, and I would believe if you're changing the business structure, they won't very much. It won't be a sheltered workshop setting anymore. If you're doing business, what other businesses do, then you would have to change the employee relationship for the individuals that will be working in your setting.
I would say,
hey, Pat.
Yes.
This is Caitlin. I'm sorry, I just want to jump in. We had a question that came in just a couple of minutes ago, and I just noticed it now. So I'm sorry, Andrea, I wasn't watching this closer, and you may have already answered the question, but I'm going to put it out there anyways. Andrea said, are there notice requirements for interns regarding anti-discrimination rights, and are the same postings used to notify employees sufficient?
You know, I would say as a part of onboarding, there are a variety of different things that you'd probably want to be covering. If in fact you have an individual who qualifies as an intern under state law, which many, if not all, of the individuals you're working with would qualify. I expect that the New York State the New York State Division of Human Rights is going to be expecting and applying the same kinds of standards to interns as they would to employees. So I definitely think including interns as a separate part of your policy, so including them in the list, employees and interns, so that we preserve the argument that we've protected those individuals, and then covering it, particularly with harassment cases. For those who don't know, there is a defense if we can show we had a process in place, we communicated it effectively, and individuals didn't use that process, that there may be a defense to the employers because the individual didn't use that exception. I would definitely consider including that as a part of your onboarding process for interns or other individuals, whether they're paid or unpaid. Now, for very short-term individuals who are very closely monitored, maybe it's less of a risk, but if you've got folks who are going to be there for any length of time, it's probably good to have some information to those folks.
So thank you for letting me make the commentary that the IRS there.
No, absolutely, absolutely. Okay, so so now we have 2001 IRS guidance, and they were talking about some of the decisions or some of the advice that they had given along the line over the years. They separated individuals into two classes, Class 1 and Class 2.
That's simple.
So Class 1, they're looking at average training of about 16 weeks. It was intended to prepare somebody for placement in private industry. The hours were limited because the individual didn't have the capacity to work unlimited hours or a more traditional schedule. There was counseling and other services provided as a part of that, so they certainly supported. There may have been some monetary allowances, but they weren't eligible for benefits. And they, during this training program, the rehab organization was supervising and directing the individual as part of their rehabilitation, and they were providing protective services to make sure that the individual was getting what they were needed and weren't being abused. So for that particular group, they determined that there would not be an employment relationship in that case. Okay, so now we have Class 2. Those individuals had completed training. They could perform one or more jobs in the sheltered workshop program. They may still be working in the sheltered workshop temporarily while they're looking to get placed someplace else, or they may be working in the workshop permanently if they're unable to complete in private industry. So it doesn't require that they are working unimpaired. It just, we're now gotten to the point where it's not temporary. They're able to work fairly independently, either in the workshop on a permanent basis or temporarily when they're looking to go someplace else, waiting for an opening. So in this particular Class 2, They said, look, the working conditions, the pay scales are going to be comparable to what we're seeing in private industry. There are going to be regular hours. There are going to be established production schedules. It looks more like traditional employment in that regard. The individuals were eligible for benefits. They could be discharged if their work was unsatisfactory and there was an intention to have an employment relationship. So in those particular cases, the IRS said that there would be an employment relationship. Now, many of you may be thinking, right, of course, no duh. I mean, you said an employment relationship was intended. In the other case, the situations were very different. When I'll speak for the agencies that I work with. When I see guidance, very often what the agencies are doing is providing very clear contrast. They're taking the safe, fairly obvious examples. So we know that generally speaking, we don't have class 1 or class 2. We have like class 1.3 or class 1.7. And so there's something in between. And where will that apply? Well, this guidance doesn't really provide us a lot of information. So some people may say, look, we don't intend to have an employment relationship. We don't provide benefits to our to the individuals who are working in our sheltered workshop, and ergo we are in class 1. Well, that's not necessarily the case. It may be that an individual is eligible for benefits. You're simply not providing them, and that's a whole other seminar. But just be aware that, like, so we've got these two contrasting situations, but most of our situations are going to fall somewhere in between. So how do we determine whether somebody is, if there is an employment relationship or there isn't? Well, obviously, if there's an employment relationship intended, then in fact you're going to have to pay FICA and withhold for income taxes. If individuals are earning a living based on what they are earning for the services they're performing. If they're displacing services of regular employee, and I would add, building off of what Pat was talking about, when you have individuals who are working side by side with individuals who are not identified as having a disability, I wonder if the IRS is going to look at that differently, because now we may have displacement of services of regular employees. Probably the processes, the expectations we're using are going to be a little bit more similar and uniform, although there may be some differences. So that might be a place where we see something moving towards more towards the class 2. Comparability of pay compared to industry standards. So it doesn't necessarily mean that it has to be equal to, but we're looking to say comparability. And I would wonder for 14C, depending on where a person lies in terms of impairment and how close to full pay that they're getting, the more likely we're looking at class 2. So to the point we made before, you may have one program, one 14C covered sheltered workshop, but you may have employees who are at one end of the spectrum or another or somewhere in between, and we have to assess individually because that's how the agencies are going to look at it. So we really want to be careful about not just making a very general assessment based on the program. Looking at benefits, although remember that none of these particular things is a deciding factor per se. Setting the hours, production schedules, and how the relationship is between the workshop and the individual. So one thing to look at is this more protective, supportive kind of work environment, or are we at the point where we're really treating this individual more as an employee? So we might discipline or take action if an individual is engaging in unsatisfactory work performance. And finally, something that we're seeing more recently is it short-term work experience or is it a long-term work experience? The longer term it is, the more likely we're in a class 2 type situation. So we've talked today about the letter, the 1993 letter, and the 2001 guidance document. So what do we have in terms of challenges on relying on either of those? One is, as I suggested with the letter ruling, there are limits to who can rely on that letter, because it's typically the organization that wrote the letter, and they are very clear to say this doesn't create a precedent, meaning that usually in the law we'll say, well, you've always treated this, or this is the way that it's been handled in the past, so that's how it should apply here. This wouldn't be able to be used as one of the examples of how things typically would work in a way that would bind the agency or the courts. Similarly, as I said, you know, even the 2001 is a little bit older.
16 years.
And don't remind me. Feels like 2001 wasn't that long ago, but it was 16 years, 1993 even longer. And the law continues to change and evolve. Different administrations take different perspectives on how rules should be applied. The guidance that we get is fact-specific, tends to be fairly general when they're issuing guidance or their particular perspective at any given time. It's always fact-specific, and so to the extent that there are any differences between the facts as we have them and the facts that are outlined in the guidance, that may be a basis for applying a different kind of standard. Even if you were looking at the facts at the time and it was accurate at the time, if the facts have changed over time and you now have a different set of facts, you're not going to be able to rely on that letter. So I'm sure we're going to have questions. I just wanted to hit paid family leave because that's really the hot topic right now. It's a very sexy topic in employment law circles and in HR circles. So how might that apply to individuals who are in work experiences? Well, just generally, for those who aren't following this as closely as we are, paid family leave is effective beginning in January of this next year. It provides up to 12 weeks of leave. It actually incrementally increases over the course of the next few years. And individuals who are eligible are those who are caring for family members with serious health conditions, those who are caring for newborns, newly placed children due to adoption or foster care, or what we call qualifying exigencies related to military service. So if somebody's being deployed, for example, and there are things like getting wills together or making child care arrangements, or going to supportive services for military families and those sorts of things, individuals can take time off for that. So with the individuals that we're working with, qualified, there is a specific notation in the statute that says an individual who's participating in and receiving rehabilitative services in a sheltered workshop operated by a religious, charitable, or educational institution under a 14C certificate is exempt. But now remember, you know, as we said, if we're moving away from sheltered workshop placements, this law isn't going to fit quite so nicely.
Right.
And so we do have to be thinking about that as we're going through. Otherwise, an individual is eligible if they've worked 26 weeks for an employer, and we're looking at those are for those folks who are working 20 or more hours a week, or 175 days if less than 20 hours. And so paid family leave is a whole other discussion altogether. But just generally speaking, be aware that may have some application, and it's good to be looking at kind of programs that you're either putting together or you're operating to make sure that you know how this might apply to your folks. Okay, so in terms of follow-up, you definitely want to make sure that you're assessing programs, but as I said, don't forget to look for possible subcategories of workers or even individuals who are within the program who maybe are different than others. So don't be so quick to make decisions based on the whole category. It's important to consult with attorneys, particularly when it's a close case. You want to make sure that if there are things that you need to do now at the onset to kind of place yourself in an exception, that you do that now, or that if you really can't find an exception, that you're making that change now. Particularly with wage hour law, the statute of limitations is 6 years. That means if there's a claim filed today, the Department of Labor or a court could look back 6 years to see what is actually due to the individuals. And so we're looking over the course of 6 years, week after week, even if it's small amounts. If we're looking at 6 years plus however many people are affected, it can add up. In wage hour law, if you owe a certain amount, let's say you owe $50,000, that amount is doubled in order to it's called liquidated damages. So that's to help do two things. One is to compensate for the individuals for the fact that they didn't get the money when they were supposed to. It also serves as a deterrent or a punishment for organizations who aren't paying the money that they're supposed to be paying. Additionally, you can have attorney's fees associated with that, not just your attorney's fees, but also the attorney's fees of the employee or the employees who are asserting the claims to begin with. If you have class actions, it's really very expensive. It can take $100,000 just to establish who's actually in the class and who's not. So it really can be quite devastating. You'll want to ensure, as a part of this, as a part of the thoughtful assessment of the different work opportunities that you all have, that you have the appropriate documentation. So as I said, if you're if you're doing this, you probably want to have notices regarding compensation, benefits, no promise of employment at the end of the experience, those sorts of things, and make sure that the relevant parties are signing off on that. So it may be the individual, but it may also be their representative or other parties who would participate in that placement. Okay, so I know that I have talked a lot here. We've covered a lot of different areas. Do folks have questions?
Joanmarie, I'm not seeing any in the actual questions box, but everybody that is on the line, I can unmute your microphones if you raise your hand using the button in your control panel and ask away. Anybody?
If not, that just means Joanmarie is cool and knows how to coach.
Or everybody's so devastated or shell-shocked they don't process questions.
No.
And that's okay too.
But I do know we talked to you about possibly adding to this around the difference between part-time FTEs, full-time FTEs, hourly workforces versus so here you've described terminology that sets the stage for a hiring practice, and now I'm thinking, based on some stuff that I learned yesterday from people and a bunch of different things, it'd be fun to talk to you more about now. Help us figure out the best way to consider setting up the workforce so that it meets expectations and we can greet it with, support, whatever, that kind of stuff. So I'd love to talk to you some more about that in regards to, because one of the things that the agencies that have used the ruling letter are betwixt and between is the cost of adding those the required benefits when they haven't been doing that. But I'm hoping that if you're on the call and you were specifically looking for that definition, it appears that, Joanmarie's saying basically right from the get-go it could cost you as much as $100,000, and I'm guessing that adding in FICA and Medicare payments is going to be a heck of a lot less than not meeting those expectations of that and somebody suing you for things that you didn't do for somebody, so in a class action suit. So I don't need to scare either, but I think it's time that we revisit all of that discussion. So if you're an organization that has that issue, and the slides here were perfect, and I know they will be available to all of you, right, Caitlin? How are we going to do that again? If you would just share with people where they can get the slides.
Yeah, absolutely. So they're actually available to you all right now in the control panel, the GoToWebinar control panel. Close to the bottom, you should see a little box that says handouts, and it's got a little arrow next to it. If you click that to drop it down, you'll see 4 handouts in there, including 2 handouts from part 1 as well as the PowerPoint, and then part 2's PowerPoint, the one that she did today, is included in there as well. So feel free to download them. And we did get a question. Lisa Bloom actually chimed in, and I've unmuted her microphone. So Lisa, if you have a microphone, feel free to jump in and ask your question.
Can you hear me, Pat and Joan Marie?
You can.
Okay, great. My question was regarding the letters of understanding. Was it possible, do we know if NYSARC did that letter and then the chapters fall under their letter?
Good question. I don't know.
Yeah, so my understanding is that that the chapters are actually a part of the one entity. And so it is possible, at least in terms of hitting the argument that it is directed at the particular, or that is the requesting entity. You might have an argument based on the fact that it is, assuming that that corporate structure, my understanding is correct, that at least you could make the argument that that letter would be sort of in the family and that you could, you know, use that argument. Remember, however, that there are many, many other factors associated with that. So that's just one factor, but also, are the facts the same? Is the law the same? How does this administration or future administration see it? So there are a number of different factors, but in terms of reliance, you may have an argument that would qualify. It would require an assessment of, you know, the relationship.
Lisa, overall, I don't think that NYSARC perhaps has done that on behalf of all of its chapters, because I'm aware of 2 in particular individual ARCs that have their own letters written to them from the IRS.
Okay, and we might, I'm not sure, so that's why I was asking. And something, I remember it had come up for us at one point, and I remember we used the argument that we had the letter. I just don't remember if it was our particular letter or NYSARC's letter, or I know it sufficed for what we needed at the time with NICE.
Are you actually giving people at the end of each year a 1099?
Is that the I know for the people in the work center we do as independent contractors, to my knowledge, which I never thought we qualified under that. We raised that to our higher ups. You know, they had whatever and justified, and like I said, it actually got us through a NICE situation. So
I wouldn't doubt that it would get you through NICE, but it won't. I don't think you're gonna. It's gonna fly easily under labor. I know that one ARC has indeed fought it off once, but again, and that's because it still was operating a sheltered workshop. As organizations make decisions to change the business function of the business that you now call a sheltered workshop to something else,
right,
there goes the justification for you to continue considering any of those folks in the same way that you were with the ruling under the sheltered workshop category. So they're 2 different animals, or they will be 2 different animals, and to think that one just transfers may not be the best decision. So what we just learned from Joanmarie today, you've definitely given me more ammunition to assist execs to make these decisions. So Lisa, if you need me to talk to Rick or anybody else, to execs or leadership in the business office, here's the slides. Start there. If not, let us know and we'd be happy to assist.
Yeah, because that's what I was going to do, Pat, was kick this over to Rick, because I know that was part of the consideration, and I appreciated you pointing that out earlier in the presentation today. And then it's good that I'll let him know if he has further questions to give you a buzz.
Absolutely.
And one other piece that I just want to say sort of tangentially is that if you were reporting income to the IRS, that you could be issuing a 1099, but there might be different categories under the 1099. So oftentimes when we say we're 1099ing somebody, we presume that it's an independent contractor relationship. So just because you're issuing it doesn't necessarily mean that it's incorrect, but you do want to make sure that you're reporting the information consistently with how you're treating.
So that's why I'm thinking the next round of our next webinar is going to be looking at independent contractors, hourly workforce, part-time equivalents, full-time equivalents, just to kind of bring everybody up to speed on what that means, and then they can make their decisions on how they'll build their workforce in whatever environment they're going to offer a work experience or a paid work experience, a paid work job. So,
Yeah.
Cool. Thanks, Lisa.
All right, Pat. So, Marcia Lazarus actually typed in a really great question. And Marcia, yes, I've unmuted your microphone, but I feel terrible making you ask the question when you typed it up so well. So I'm going to ask her question and then leave her unmuted so she can respond. So here's what she says. In terms of meeting qualifications for doing unpaid work experience, does the community-based placement agency need to be funded as a rehabilitation agency, for example, by OPW, OMH, XSVR, or can the agency be one that works with folks with disabilities, quote, unofficially, and provides work-ready type programming, for example, a YWCA or some kind of supported housing program? She goes further to say, if the answer is yes, is it correct to assume that individuals' disability needs to be documented by a medical or behavioral health provider?
So, hi, Marcia. Wait, are you talking specifically about the New York State exemption that we were talking about for those whose work may be impaired by age or disability?
I would say the New York State or the federal that you talked about last week.
Okay. So for purposes of the federal, I think, yes, you would need to have a more formal program. For New York State, the focus is primarily on the individual, and if they were providing services to a charitable, religious, or educational corporation or organization as a part of the work they're doing, I think that would satisfy the requirement, even if that organization wasn't specifically providing rehabilitation services as part of their core mission, as a part of a regulated program. Just recognizing, of course, that you'd need to meet all of the other standards in terms of documentation, as you pointed out. Does that?
So the work experience could not be in a for-profit organization?
Not to qualify under that particular exception. We'd need to find other exceptions.
Okay. Thank you, Joanmarie.
Anybody else have anything for the moment? You know, you've got the email and all the contact information there for Joanmarie directly. She's open. You know, just make sure she knows that you were part of this seminar, and she'll be happy to give you a free answer. If you are interested in doing other work with Joanmarie, she's totally open to that as well. That's part of the reason that we partnered together, is to make sure that the experts that we've learned about are the people that are working on behalf of our members and others that are partners. This is our first venture in offering continuing education credits together for HR professionals as well as social workers, and we're excited to tell you that we're also now eligible under state ed to provide LMHC credits. So in the future, our training will also be offering that to those of you that have those credentials or colleagues of yours. So please let people know. We'll be announcing that in a bigger way shortly with the rest of our annual training curriculum. But you can certainly send me an email or Caitlin an email as well, and we'll be able to forward it on to Joanmarie to get the answers for you as well. But I do think that looking at how do we build a workforce and thinking about that may be a neat place. But two, if you guys all have some other ideas, or this prompted or sparked something that, like, gee, I wonder if, or I wish they could, we are definitely open to that. And Caitlin, we have an evaluation, right, that's going to go out after this. Could you just share that, and then we'll say goodbye to all our colleagues. Okay.
Yeah, I'm here. Sorry, I was talking to Nicole. Apologies. What was your question, Pat?
I asked if you would just share that there's going to be an evaluation that would allow them to not only read the value of this, but also tell us other ideas in this categorical theme of things that they might like to hear from Joanmarie on.
Yes, absolutely. So in the email that I sent everybody for credit this morning, there was a link that includes the post-test and evaluation, but everybody who's not going for credit, you're going to receive an email from me shortly after this webinar ends with a link to just our blanket evaluation, but that's exactly where you can put in any sort of topics or other information that you would like to share or ask for training on. So just be on the lookout for an email from Caitlin at nyrehab.org to let us know. So.
Perfect. Thank you all very much for sharing yet again another Friday morning with us. We are excited to offer this kind of information and happy to have a partner like Joanmarie Dowling and her firm now firmly with us here at NYSRA. So have a wonderful weekend. Get in touch if you need us. Otherwise, we'll talk to you soon. Take care.
Thanks, everybody.